Just moments ago, Alberta tabled a bill to invoke the Alberta Sovereignty Act. Never before used, it's meant to help Alberta reject federal laws it sees as unconstitutional or harmful to the province. In this case, Alberta is pushing back against the federal government's clean electricity regulations. For more on this, the Premier of Alberta, Danielle Smith, joins me now. Premier Smith, good to see you again.
Hi, David.
Your province, the Alberta-Ottawa Working Group, has been working together on the draft electricity regulations. So why did you choose to use the Sovereignty Act rather than continuing further in negotiations with the federal government?
Well, we've been very clear from the beginning that we wanted to align our various policies around our 2050 target to be carbon neutral. And they keep on resisting that on the clean electricity regs. We're making great progress on other issues, on small modular nuclear, on discussion of hydrogen, on carbon capture utilization and storage. But we had to draw a pretty firm line here. We just know that the 2035 target is not achievable. Our own electric system operator has said that they're concerned about reliability and affordability. And we know that we need to take actions to make sure that we get more baseload power built. And in our province, that's natural gas power. And that's the reason why we had to invoke this today.
You're talking about creating a crown corporation that, if necessary, could build gas baseload power or buy gas companies who are unable to comply with the federal regulations, and talking about giving a directive to government entities not to comply with, enforce, or follow the federal regulations by any means. How is it legal for a provincial government to tell people to ignore a federal law?
Well, you know, the way I put it is, how is it legal for the federal government to act like the Supreme Court of Canada didn't just admonish them twice to stop overreaching into our areas of jurisdiction? In the first case, with the Impact Assessment Act, they told them very clearly that cooperative federalism means just that. You've got to cooperate. You can't take unilateral action. And in the case of plastics, they were told that they had overreached and it was also unconstitutional. And yet they keep on acting as if the Constitution doesn't matter. So our Sovereignty Act resolution today said the Constitution does matter. Provinces are given exclusive jurisdiction to develop their own electricity grids, and we intend to make sure that we're doing so. And that the federal government, if they don't like it, they can take us to court. But I do believe that we're on pretty strong ground here. But
you do have the authority under the Constitution to build your own electricity system. But the Supreme Court ruled in the Greenhouse Gas Pollution Pricing Act that the federal government, under the principle of peace, order, and good government, can regulate emissions. So you can't build an electrical system that emits to a point beyond the federal standard and threatens the rest of the country. This is what the Supreme Court ruled. I appreciate the IAC, the plastics ban, but those are separate issues from this particular one.
Well, I disagree. I mean, if you look at that legislation or that ruling, what they did say is it applied to the very narrow question of carbon pricing. It was not carte blanche for the federal government to use a pretext to invade provincial jurisdiction. And in fact, I would say the subsequent decisions have made it super clear that the federal government can act to regulate federal projects on federal lands and international, but they cannot use their power to invade our jurisdiction. And they continue to act as if that Supreme Court decision did not come down. And we're letting them know that we read the Constitution, we read the court decisions, and we're prepared to do what it takes to make sure that we continue to bring new baseload power on in our province. And in our province, that means natural gas.
Okay, but if there's a federal law on the books, Premier, and you are instructing people who work for your government not to comply with it, and if they follow that, you're leading them into legal jeopardy.
Well, I guess, you know, I'll watch and see what happens in Saskatchewan, because they're a little bit further advanced. They're taking an action on a different issue and indemnifying all the employees of their crown corporations. And that's not unusual. We actually have seen in law before that you can indemnify civil servants when they take action at the direction of the political direction. So I'm going to watch and see what they put in place. And if we need to, we'll put similar architecture in place as well to make sure that our employees are protected. But what it comes down to is the federal government needs to stop acting in a lawless way. Respect the Constitution, respect what the court has said, come to the table and work with us on a 2050 target, because we are, and I have said from the very beginning that we are committed to making major reductions in emissions, but we have to do it at a pace that technology allows for, that makes sure that we have affordability and reliability. We've got to keep the lights on, and that's got to be the #1 goal.
No, I appreciate that, and I don't think anybody wants an unstable Alberta electrical system, but you cite the Saskatchewan example, and you know, I've seen a lot of legal theory that the basic principle of paramountcy, that a lower legislature, like a provincial one, cannot rewrite how federal law is interpreted, means that what they're doing there is not going to stand the test of time. And it seems like the potential exists, and I am not a lawyer, but the lawyers who weighed in on the Saskatchewan one suggested they could be led into legal jeopardy because it doesn't matter what you say provincially, it matters how the law is interpreted federally. So I mean, how risky is this going to be for the people you're telling not to follow federal law?
With respect, David, we are not a lower level of government. We are an equal level of government. We each have sovereign areas of jurisdiction defined by Section 91 in the case of the federal powers and Section 92 in the case of the provincial powers. I'm annoyed that the federal government keeps treating us like we are a lower level of government and that they can enact laws in our areas of jurisdiction with impunity. They cannot. The Supreme Court has told them they cannot. The federal court just told them that they cannot. And as a result, this is the reason why we have decided to take the action, that we're going to make sure that we get our power produced in this province where we have our constitutional jurisdiction to do so. Look, we have had instability in our grid already. The grid almost failed 7 times last winter and 3 times over the summer. This is unusual. And what it's showing is our system's under stress. We need to bring more baseload power on. And yet, because of federal interference in this area, I do not have people knocking down the door to create new natural gas plants because they're fearful of what the federal rules are going to be. And this is the reason why we have to create an environment to get those investment dollars back so that we can make sure that the lights stay on in the winter and in the summer, and to make sure that we are able to protect Albertans. That's what's got to be our #1 goal. Okay,
fair enough on my use of the word lower order. That was probably a clumsy characterization, but the point stands that the federal government can't rewrite provincial laws any more than a provincial legislature can rewrite federal laws. And you talk about how you need baseload power. Why not look at other options beyond gas? For example, hydro. I've seen a study done in 2010. This is on the government of Alberta's website. There's 42,000 gigawatt hours per year of undeveloped hydroelectric potential in Alberta. That's enough for 5.8 million homes a year. Why is this all about natural gas when there are other options that exist within your jurisdiction?
Well, I look at what's happened with Site C, and as you saw, the Site C project began as an idea in 1954, and it's taken decades and decades and decades to get to a point where they had enough buy-in to be able to do it. Plus, it's expensive. It's an 1,100 megawatt facility that is costing $15 billion. We're bringing on a 900 megawatt facility next year that costs $1.5 billion. So the money makes more sense in this province to do natural gas. We will do abatement to the best available technology, and we'll work with the federal government on small modular nuclear. We've signed an MOU with other jurisdictions on this, and we've also funded a study looking at how Synovus might end up implementing that. But that is technology that doesn't exist yet, and it is not deployed yet, and we don't have a regulatory environment for it yet. Hydrogen is another great potential opportunity, but again, these are all types of technology that are still in their infancy. I can't guarantee that they're going to be ready by 2035, which is why we need the longer time horizon. And I hope the federal government understands we're serious about this. We want to work with them on carbon neutrality, but carbon neutrality by 2050.
These regulations, though, are still in their draft form. They're not finalized yet, and you're taking this step. I mean, has it been made emphatically clear and absolutely that there is no flexibility from the federal government?
I made it emphatically clear when they were first proposing it. I said, do a carve-out for Alberta, Saskatchewan, New Brunswick, and Nova Scotia if they need it as well. These 4 provinces that are in a very different situation. There are some provinces that are already almost at net zero on their power grid, but give us a little bit more time. I made that point over and over again, and they continue to press forward with unrealistic targets. And so this is the reason why we've had to take these matters into our own hands. It takes years for the commission of a new site, going through the regulatory process. We can't afford to wait while the federal government stalls and make us go to court to try to win our constitutional authority back. We're asserting our constitutional authority, and we're going to get started on making sure that baseload power gets built.
When we spoke about this the first time, and in a subsequent conversation I had with Rebecca Schultz, one of your cabinet ministers, you raised the prospect of people going to jail if you're not in compliance with these regulations in 2035. And the government has said that good faith non-compliance will not lead to incarceration. There's a quarter century of regulation under the Canadian Environment Protection Act that demonstrates non-compliance is addressed with warnings, compliance orders, and gradually larger fines. And that's why it needs to have a criminal code provision. But what you're talking about is not a good faith non-compliance. You're talking about a deliberate non-compliance by telling people not to comply.
No, No, not true. I mean, when we are talking about bringing on natural gas, we're talking about bringing it on abated to the best available technology. The problem is right now the technology only allows for us to abate about 60% of emissions, which is pretty good, but it's not anywhere near what the federal government is asking for. And so that's why we believe we have to take these actions. And it's not good enough for them to use their criminal law power to invade our jurisdiction and say, oh yeah, but we don't really intend to use it. That does not give comfort to our private sector CEOs. Our private sector CEOs are very risk averse, and their boards of directors will simply not allow them to take a risk that one of them is not going to end up in jail in 2035. We need this clarity, and that's what we're providing. We're going to make sure that we have a market that investors can invest in, and they know that if there is any risk, the risk will fall to the provincial government.
Just as a final question, Premier, have you spoken to anyone in the federal government since you announced your intention to do this, and what was that conversation like if it happened?
Well, I did tell them from the very beginning that don't go down this path, because otherwise we will have to assert our constitutional jurisdiction. I did tell them at the very beginning, before we even put our working table together, that we wanted them to align around our 2050 target. When we launched our campaign across the country to try to educate the rest of the country about the impact this would have on us, we thought that that would move them. Instead, they just continue to proceed as if they can tinker around the edges and continue to act like these targets are achievable. They're simply not. So now they know we're serious, that we are going to defend our jurisdiction. We're going to build the baseload that we need, because Albertans expect us to keep the lights on, and that's our job to do it.
Alberta Premier Danielle Smith, thanks for your time again today.
Thank you.
The Minister of Energy and Natural Resources, Jonathan Wilkinson, joins me now. Minister, thanks for joining us today.
Not at all. Thanks for having me.
I wonder what your reaction to Danielle Smith and her government choosing to do this now. What's the significance of this move by Alberta?
Well, I think it's unfortunate, and I think it kind of represents the victory of partisan politics over good public policy. I will tell you that we established a Canada-Alberta working group. It has now met 5 times over the last few months. 4 of those were on the clean electricity reg. The working group actually was making very good progress. I think it's been a highly productive tool where I think Alberta's come to understand the regs a little bit better, and we have come to understand some of Alberta's concerns and thoughts with respect to how to improve the regulations a bit better. And I think we've been making enormous progress. So, you know, the fact that she launched this today without telling us at all that this was something that was on her mind at a time where I think we were actually headed towards finding a pathway to doing this in a way that would work for Alberta and for Canada. I think it represents a victory of partisan politics over good public policy.
Well, what would that pathway look like, Minister? Because, you know, Danielle Smith and others in her government have flat out said there's just no path forward without a significant amount of natural gas as part of their base load power supply. And the technology and the capacity just isn't feasible for them to hit a 2035 target. So how do you see Alberta getting to the point that they're in compliance with the regulations in 12 years?
Well, with due respect to Premier Smith, and I know her, and I have respect for her. I mean, what she's saying is not actually the case. You know, all the G7 countries have a net zero by 2035 aspiration, but all of us have regulations that actually provide for some flexibility with respect to gas in particular, to ensure that we don't end up with significant stranded assets. And so, if you look at the draft regulation that was put out, if you built a natural gas power plant in 2024, it can run unabated until 2044. There's a 20-year period. And so there is certainly opportunity, and we have been discussing whether there was a bit more flexibility that may have been required with respect to that particular provision and other provisions in the regulation. The regulations also allow for gas with abatement. So you can put carbon capture on a gas plant. So we recognize that Alberta is going to need to continue to use gas for some period of time, and certainly have provided for that in the reg. And what Premier Smith is saying, she knows is not actually really the case. It doesn't mean that you all of a sudden shut off all the gas plants in 2035. That wouldn't work. And we are as cognizant of that as she is. At the end of the day, I think we all want to get to a grid that is reliable, that is affordable, but also ultimately that it's not emitting. I mean, Alberta and Saskatchewan and Ontario and Nova Scotia are not going to be able to attract industry unless they're able to offer people a clean grid.
Well, Stephen Guilbeault, your colleague, the Environment Minister, said not too long ago that you're going to move ahead with this. There's no legal basis for what Alberta is doing, and you feel you're on very solid ground, and that you're not going to back off on the 2035 targets. Is that the clear position of the Canadian government? No matter what Premier Smith does in the legislature, you're pushing ahead towards 2035?
Well, I would start by saying, I mean, we look for, and I continue to look for pathways through which we can actually collaborate to get to an outcome we can all accept. That was what the working group was about. And I think that was actually the path in which the working group was headed. But if you're asking me about the constitutional basis, I mean, at the end of the day, the government's power to do this under the Canadian Environmental Protection Act, I think, is reasonably well settled law. And from a constitutional perspective, and David, I will tell you, I used to be a constitutional negotiator. There is no provision in the Constitution that allows the provincial government to essentially shield itself or say that they will not enforce federal laws. That just doesn't exist, nor can it exist in a country that actually prides itself on the rule of law. It just doesn't make sense.
So when Danielle Smith says they're going to order government entities not to comply, not to cooperate, not to follow federal regulations, is she putting those people at legal jeopardy if they follow her instructions not to cooperate with the federal government on something that you believe is entirely in your jurisdiction?
Well, I would just tell you that Canadians, you know, when we talk about the Canadian Constitution, we talk about peace, order, and good government. Canadians, by and large, are people who actually have respect for the rule of law and expect that their neighbors and their premiers and their elected officials of all kinds are actually going to abide by the law. I continue to think that Canadians will operate in that basis. And to be honest with you, rather than having this kind of an argument, I'd actually rather be sitting at the table and trying to figure out solutions that will work for Alberta, that will work for Canada, that will work for Saskatchewan, that will work for Ontario. That's what Canadians should be expecting of their politicians, not playing these kinds of partisan games.
But can you even sit at that table now, Minister, if they say they're going to instruct all of their entities and agencies not to comply, not to cooperate? They're passing this resolution, and she's flat out said that it's mission impossible to meet what you're laying out there.
Well, I will tell you that there is another meeting of the working group that's scheduled in December to actually talk about a specific area of interest to Alberta, where they have some concerns, and we are actually asking for their input on how to actually address those things. Our intention is to continue to have those conversations in good faith and to try to find outcomes that are actually collaborative outcomes. I think that's what Canadians should be expecting of their politicians, and I will continue to do that, even in circumstances like we find ourselves today, which I think is a very unfortunate place.
But you know, part of what Premier Smith says is that industry wants certainty. They feel they can't comply with these things, and this creates an uncertain investment climate. I'm sure the federal government would argue that her actions are in fact creating uncertainty by not complying, and they're going to have difficulty in attracting investment. Lisa Raitt just proposed the idea of why not a reference case or an opinion at the federal court level on these clean energy regulations to deem their constitutionality and get some final clarity on it and let industry make up their minds based on that. Is that an option you would consider, or where are you on that?
Well, let me first say that I have great respect for Lisa Raitt. She's a super Canadian, and she did great work when she was in political life, and she does great work in the work that she's doing right now. But what I would say is that the federal government's powers under the Canadian Environmental Protection Act are a matter of settled law. I think we're pretty comfortable that we actually do have the ability to move forward in this basis, but we want to move forward collaboratively. We want to move forward in a way that Alberta and other provinces actually see the benefit of doing that. And I will just say to you, a clean grid is an economic enabler for all provinces. They will not be able to actually attract the investment that they want without a clean grid. But if Premier Smith wants to challenge the legal basis of the regulation, she's certainly open to do so. But I would say that, in my mind anyway, this is an area where the law is quite clear. Well,
she seems to be, just as a final point, almost like daring you to take her to court. That was certainly the impression we've gotten from it. Do you think there's any way this doesn't end up in front of a judge at some point?
Well, I think, look, people should take a step back and try to find a conversation where we can actually move forward together. When Premier Smith says this is about having zero emissions by 2035 and shutting down gas plants, she knows that's not true. If you read the regulation, that's not what it says. She says 2050. A lot of the flexibilities under this reg actually get you a reasonable portion of the way towards that in many cases. So at the end of the day, there's a basis here to try to sit down and figure out how we do this. As I say, nobody has an interest in a grid that's unreliable. Nobody has a grid that's unaffordable, an interest in a grid that's unaffordable. And everybody has an interest in a grid that's not emitting. So, I would just say, let's stop with the partisanship. We are all Canadians. let's sit down and figure out how to make this work.
Minister of Energy and Natural Resources, Jonathan Wilkinson, thanks so much for your time.
All right, thank you.
Thank you, sir. Okay, we're going to get back to this with the Power Panel. They've been listening in. Rob Russo, Vandana Cotter, Brad Levine, and super Canadian, Lisa Raitt. Well, Lisa, just quickly, your quick response to that. I mean, if Danielle Smith wants a loud, aggressive fight, I don't think she's going to get it from Jonathan Wilkinson. I can't speak for everybody in the government. What did you make of the federal response there?
I think Minister Wilkinson put it out really well. He said, we want to negotiate, and the Alberta Premier is saying we want to litigate. And that seems to be where we are. And there may be a case to be made that Alberta just fundamentally does not want to have federal jurisdiction within electricity generation, period. And they're willing to go to the wall on that. So they won't accept any kind of regulation in an area that they view as being very much in the provincial jurisdiction. So right now, it looks like Alberta wants to litigate and the feds may want to negotiate. And at the end of the day, we all lose.
Brad, I didn't get a sense from the minister there they were looking to escalate, that's for sure. What's your reaction to what we've heard from both the Premier and the minister?
Well, certainly, I think the minister was overly polite, and I guess he has to be that. But folks on the Power Panel don't have to be. I think for Smith, her Sovereignty Act, the law that was passed in the Alberta legislature, talks about how they can invoke it and deem whether or not the federal government is being unconstitutional or, quote, harmful to Alberta, not only on laws that are passed the Parliament, but on even proposed or anticipated regulations or laws that are passed. So, you know, to keep her Sovereignty Act whole, she's probably anticipating. The notion that what the feds are doing is somewhat harmful to the certainty that the business or investor communities are looking for. It's absolutely the opposite. Everything that she's doing is imposing a high level of risk for investors when it comes to the province of Alberta, because we don't know. Well, I mean, she's speculating that what they're doing is legal, which I would be on the side of those. And again, I'm not a lawyer, but I think the feds are within their rights. Just because they were outside of their jurisdictions on plastic doesn't mean that they're not within their jurisdiction. They were, by the way, on carbon pricing. Alberta took Ottawa to court over carbon pricing, and Ottawa won. And I think a lot of people would think that Ottawa is going to be right with their Environmental Protection Act that Minister Wilkinson was talking about. But the level of uncertainty that Smith herself is claiming Ottawa is providing, she herself is providing, because if you were to invest in Alberta, in the electricity grid now, or in that, you would have no idea whether or not what Alberta is doing is right, whether or not it's going to be held up in courts for years upon years. The whole thing is outrageous, and I think Smith should give her head a shake.
Well, and Rob, one of the provisions in the resolution today is to explore the possibility of creating a Crown corporation that, if necessary, could do natural gas developments or buy or nationalize or acquire in some way existing private sector natural gas projects, so that you can't force a private company to defy the federal law. You bring it in-house and you do it through a Crown corporation. I mean, there's quite a few things at play here.
Yeah. You used a couple of interesting words: explore the possibility and if necessary.
Right.
I'm reminded of family gatherings when I'm not writing for the leading English language magazines in the world, David.
Two of them.
I go to family gatherings, and young cousins and my niece and nephew love the fact that I do the magic quarter trick, where I take a quarter and put it in a hermetically sealed mayonnaise jar under Funk and Wagnall's porch after 24 hours, and I turn it into a teleporting quarter. I declare that it is, but their parents ultimately decide whether or not that's true when they get home at night and they're talking about it. There's going to be a lot of talk, a lot of possibles. The courts will ultimately perhaps have to decide on that. But in between then, I think we're going to see a lot of talk, a lot of negotiation. And I'm not even sure this is going to get to court. Legislatures and parliaments make declarations, courts decide.
This could be a good article for The Economist, if you know anybody who writes for that. Vandana, I mean, what did you make of the... there was a de-escalation vibe there from Jonathan Wilkinson, though he did say what she's claiming is not true. He was pretty emphatic on where he stood on the factual basis of the argument.
I mean, Minister Wilkinson's always calm. Like, that's just how his demeanor is. And I think he also knows that fighting just plays into her hands. What, Danielle Smith is doing is also political posturing to her base. To people saying, I'm fighting for Alberta and sharing misinformation about jail time, and I see the ads in Ontario. I don't think, she's trying to play to people who are already tapped up and angry at what's happening right now. So, but I think if they were to fight her, that's exactly what she wants, because I think ultimately she doesn't want to do this. I think she wants to play by her rules, and she wants to do it her way. And I think any conversation or collaboration on, trying to get to 2035, trying to get a little bit past that, because I feel like there has been a lot of, all the reading I've done on this, is that they have been working with her, and they have been trying to figure out how do we get there. But what also makes investors really nervous? A moratorium on clean energy products. And I think exactly what Brad said is that, what she is doing is making investors uneasy, and that's not good for Albertans overall.
Just very quickly, David, I was talking to a leading businessman who deals with the oil sands, who said there are two questions when people want to invest in the oil sands. Number one is, where am I going to get my power? And number two, is that power clean power? Is it net zero power? You got to be able to answer those questions if you want to invest anywhere in Canada.
To get the capital, really.
That's
to get the financing, because it's part of the risk. So Lisa, I know we are a collection of non-lawyers, that we've all said, but you are the only former federal cabinet minister in this conversation, unless Rob has yet another job that I could be wrong. What is the legal situation here, as you see it, in terms of the jeopardy for people who might be instructed to ignore the law by Danielle Smith if it comes to this? What is your take on the legal risk that's being proposed here?
I think that's so far down the road that I don't see anybody being in a position where that actually comes to fruition. I think this is a negotiation/litigation tactic that is putting really squarely in front of whether or not the federal government should be putting out electricity regulations like this in provincial jurisdiction. I think the Premier is trying to get this into a court that's going to make a decision on whether or not that is something that the feds can do. And quite frankly, I appreciate what Minister Wilkinson said, especially the Great Canadian part, but I don't know how settled law it is whether or not this electricity stuff is something as a matter of national concern that was part of the decision in the Emissions Act. I think it's a stretch. I think it's a real question for people, serious people like judges to think about. And by the way, I am a lawyer. Well, yes, I was referring to us. That's why I went to you. All right, and by the way, I have to correct you. He said super Canadian, so we may as well end this. Okay.
So there you go. All right, listen, gang.
I'll get my cape.
Yeah, thanks so much to the Power Panel, Lisa Raitt, Brad Levine, Vandana Cotter, and Rob Russo. Thanks so much, gang.